companies, there can be acquisition of companies, acquisition of shares, acquisition of managerial rights, etc., etc. They are not concerned. Now they say in para 3 that if it is CIRP, then everyone would be entitled to a green channel. Now, your lordships, may not kindly see page 22 of this very page 21, my lord, if your lordships, my lord, 10, at the foot, green channel for combinations. My lord, your lordship gets it? Yes. My lord Justice. In recent times, there has been growing international consensus that mergers are a means of companies to compete and to realize welfare-enhancing efficiencies. Therefore, delaying merger implementation imposes costs, not something is made. I'm sorry, but this is only a heading, a relevant part. But we'll place the entire on record.
There's 1 or 2 pages missing.
No, there are 5 pages, 7 pages, 6 pages missing. The entire is already on record. This is for convenience, my lord. I just give the volume 4, the big convenience compilation, from where I have again, my lord, made a micro convenience compilation. That was prepared by all parties together. But it is very voluminous, so I have taken relevant paras. Your lordships can take it from me. Pages which are missing will not help either them or us. Therefore, we have been careful.
This is volume 4, you said?
Volume 4 of convenience, joint convenience compilation. Document number 10. Document number 10. Yes. Yes. I'm thankful. I learned it. But your lordships may kindly come to the index of this today's convenience compilation. It mentions, my lord, where in the original record, which is already before your lordships, my lords would find. I'm grateful, Mr. Mehta.
Yes.
So 4.15. Finally, the committee discussed that the proposed green channel must become the preferred route for merger notifications and approval for majority of the cases. It was agreed that detailed criteria for eligibility under the green channel may be formulated by the government based on consultation with the CCI. Appropriate forms for notification under this route may also be designed keeping the aforesaid principles in mind. While discussing the criteria for eligible combinations for the green channel, the committee considered if combinations arising out of IBC should be permitted to pass through this green channel. Now, not IBC specific recommendation. The IBC involves an insolvency resolution process wherein a company going through insolvency may be taken over by another enterprise whose plan is approved by a committee of creditors of the insolvent company. This gives rise to possible combinations, and the applicants proposing such a plan, that is resolution applicants, are required to notify their proposed combinations to the CCI if requirements of Section 5 of the Act are met. The committee discussed that the insolvency resolution process is a time-bound process and combinations arising out of this may require quick approval. It was noted that the IBC was enacted with the aim of minimizing the volume of non-performing assets in India. One of the objectives of the IBC is to create a market for distressed assets to maximize the value that creditors of distressed firms will receive. Please mark, value maximization is yet another heart and soul of IB code, apart from the company remaining a going concern. It was highlighted. It was highlighted that since the key objective here is to boost the distressed asset market, it may be beneficial to ease the regulatory burden on resolution applicants. It was thus concluded that combinations arising out of resolution plans under IBC may be notified through the green channel. Now, based upon this, CCI regulations are amended, which your lordships would find at page 24, not at 25. But again, only relevant extracts, not entire regulations. Yeah, yes, ma'am. May I?
Ah.
Yes, ma'am.
It would be complete if you also read F4 5.1 on page 23.
23.
No, you finish reading page 22.
5 point, madam?
5.1.
1. I
That
read
is
5.
paragraph 5 deals with deal value threshold for combinations.
Yes, ma'am. Madam, this is not for IBC, for other general.
Then one of the sentences.
Yes, during its discussions on combinations, the committee observed that in the last decade, the 5 largest technology companies have made over 400 acquisitions globally. As noted by recent report, some of these acquisitions have been exceptionally high value, peaking with Microsoft paying $26.2 billion for LinkedIn. The committee was appraised by the CCI that industry leaders have recognized the imperative need for ex-ante assessment of acquisitions in digital space during a stakeholder consultation on digital markets and competition issues organized by CCI on 24th July. The CCI further informed the committee that CCI has set up a think tank comprising of technologists, economists, and lawyers to deliberate on the issues that arise in a new age markets. In a meeting held on November 18, all members of the think tank appreciated the need for looking at acquisitions in the digital space more carefully. This is regarding acquisitions outside the IBC. The committee discussed that most of these acquisitions are in digital markets derive value from data or some business innovation held by the target. If such acquisitions, the target may not have a huge asset base and may be offering products or services that are either free or generate insignificant turnover. For example, Twitter, the acquisition of Twitter by Elon Musk. There are no assets. It's the value of the product which is the value. This may be because the business model of companies in digital market is often such that they do not generate any significant revenue for a number of years, focusing initially on user growth. In such circumstances, the value of target sale is a rather poor indicator of transactions significance for competition. Against the background, the committee discussed the adequacy of existing asset and turnover-based threshold for notification of combinations provided in Section 5 of the Act.
Yes, please come to the other thing.
This was for different contingency outside IBC. Then, in view of this, this regulations, at page 24, Competition Commission of India, but if your lordships can, take the act, bare act, instead of reading it from here. So please take the bare act,
Competition Act.
Competition Act. So please see the definition, at 2R. When I say that this would eliminate those who are real players in the relevant market. Therefore, I'm showing 2R of the Competition Act. That your lordships may consider interpreting the provision in such a way that regular players who are in the relevant market are not eliminated because they are not getting green channel, which they are not getting right now. There is no corresponding amendment in CCA. Relevant market, your lordships gets. Relevant market means the market which may be determined by the commission with reference to the relevant product market or the relevant geographic market or with reference to both the markets. Then relevant geographic market is defined. Relevant product market is defined. And now your lordships may kindly come to Section 5. I'm just showing the scheme. I'm not either supporting or defending or objecting to the order passed by CCA. That is I'm not even a party. I'm just showing the scheme for my purpose of interpreting the proviso. That's the limited purpose. Combination, 5 combination. The acquisition of one or more enterprises.
You're reading what?
Section 5 of the Competition Act. I have shown the relevant market player, product wise, and